Former Solicitor General Paul Clement is looking to the High Court to overturn a ruling in a case that he argued and won. And at the heart of that 2003 ruling is a law that places a cap on candidate contributions in Alaska to $500.
But in a recently filed petition, Clement argues that the decision should be overturned, calling the limit too low. Joining us to discuss the impending case and the impact it could have on future elections is Richard Hasen, Chancellor's Professor of Law and Political Science at UC Irvine and nationally recognized expert on election law and campaign finance regulation. He wrote in The Atlantic about the case and warned about the creation of a world in which individuals could give unlimited sums directly to candidates. Richard, thank you so much for joining us. Richard, one thing I want to get at, which I always thought was interesting, is that this would almost be like a return to the old days in which there was no campaign finance laws. What is it about this system that could get struck down legally?
So it's not the same case that Paul Clement's trying to get overturned that he argued earlier. Back in, you may remember, in 2002, Congress passed something called the McCain-Feingold Law, which imposed a number of new campaign contribution limits. It's the kind of the reasoning of that case that he's trying to get reversed, which could eventually lead to getting rid of the individual contribution limits. So right now, if you want to support one of the candidates running for president, you can give him or her $2,800 in the primary, $2,800 in the general. And the Supreme Court said in that 2002 case and the 2003 case and other cases that these limits are fine. They prevent corruption and the appearance of corruption. And what Clement is arguing is when campaign contribution limits are too low, they're unconstitutional, and maybe you need to rethink the standard that you use. And if the court rethinks the standard the way that Clement is describing it, it's possible that all campaign contributions could be struck down as unconstitutional, which means that you'd be able to give unlimited sums directly to candidates. And that would be a big change from the way it is in most of the country where there are limits, like the federal limits.
What clues do we have as to how the court might rule?
So the court has kind of swung like a pendulum on the question of the constitutionality of campaign finance laws. In the early 2000s, when Justice Sandra Day O'Connor was still on the court, there were a number of cases, including the one Clement argued, where by a 5-4 vote, the court upheld a number of campaign contribution limits, even the ones that applied to preventing corporations from spending money in elections. Then Justice O'Connor retired. She was replaced by Justice Alito, and you must remember the Citizens United case in 2010, where the court said unlimited corporate spending in elections. There have been a number of other cases that have gotten less attention. And the bottom line is, since Justice O'Connor left the court has not upheld a single limit on money in elections, except for one applied to foreign spending. And so with the addition of Justices Kavanaugh and Gorsuch on the court, I think it's fairly likely that the court takes the case. They're likely to strike down or limit campaign contribution laws. So it's really not a question of where the court is. It looked like you've got a 5-4 majority that would strike these down. But it's a question of whether they want to dip the toe in the water again, because they've had a number of opportunities over the last few years to take cases like this. They've refused to take them. They have discretion over most cases that they take. And so really it's, do they want to accomplish this now or do they want to wait a while? And Paul Clement being such a well-known and well-respected lawyer, the fact that he's been brought into the case really probably increases the odds that the court's going to want to take the case.
Interesting.
That's really interesting, Richard, and it really gets to the core point of whether the Roberts and the court wants to take on such a controversial issue at such a divisive time in the country. One interesting thing, though, is if the individual limit was removed, would that maybe neuter the power of super PACs, because so much money wouldn't flow to the super PACs and maybe rich individuals would just donate openly to candidates themselves?
Right. So I think that it's true that so much money is going into elections these days. It's just not going directly to candidates. Thanks to Citizens United and some follow-up cases that the courts have decided, you can give unlimited contributions to a group that spends independently of the candidate. That's what a super PAC is. If the limits fell, you'd be able to give directly to the candidate. I'd argue that that creates an even greater risk of corruption because you'd be dealing directly with the candidate and potentially giving the candidate millions of dollars. There still would be these outside groups. We call them social welfare groups or 501c4 organizations. If you want to give your money anonymously, you'd have to give to one of those organizations because all campaign contributions to candidates are eventually disclosed. So there still would be a reason for outside money, but right, you'd see much more money going to candidates. And some people think that's actually better because then there's maybe a little more accountability. Others, like me, think it's worse because it means that the danger of corruption and the appearance of corruption is even higher because it's going directly into the candidates' campaign funds, and they know exactly what the donors want.
Yeah, I mean, I think it's fair. I can kind of see it both ways, because the flip of that is, because you see more transparency, because you can see directly, okay, this person gave to this candidate and then this candidate did what they want,
right,
then the public has more of a gauge of how corrupt this system really is, and there may be more impetus to actually do something about it.
All right, so one thing we're going to see is, if this limit is struck down, it only involves Alaska state elections. It's going to be a while. So I don't think any of this is going to immediately impact 2020. But one thing we can look at is how things are going in states, because there are some states where you can make unlimited contributions to candidates.
Virginia is one of them.
Right, and in those states, there's a question. You remember the scandal involving your former governor, McDonnell. There's once everything's on the table, people feel a little freer to, remember he was getting Rolex watches, and his daughter's wedding was paid for by a campaign contributor. So
right, but I guess my point is,
world.
At least it was a scandal. At least people saw what was happening and could draw that direct connection between the money he was getting from this donor. Whereas if it's all done through outside groups, it's harder to have that connectivity between the actions of the individual and the money that they're receiving. But I also want to get your thoughts on, are we at a place where, if we're going to have meaningful campaign finance reform and really undermine the corrosion of money in politics, we need a constitutional amendment? Is there another way around that?
I think there is another way around that, and that's changing the Supreme Court. The Constitution has not changed in terms of the First Amendment in well over 200 years, and yet what's allowed under campaign finance law depends on what 5 of 9 justices think on the Supreme Court. And really, back in 2016, when we were talking about replacing Justice Scalia and the balance of power on the court, I had written that the easiest way to amend the Constitution is not to pass a formal amendment, which, given the hurdles there, is basically impossible in our polarized society, is to change the Supreme Court. And I think you're going to hear a lot of talk, if Democrats take control over the presidency and over the Senate, about whether changing the Supreme Court is something that's going to be on the table in terms of potentially adding more justices to the court.
Yeah.
I think you're
we
right,
don't know
Richard.
what's going to happen there.
I think you're right, Richard. We've seen the court packing arguments reach a level in this country that we haven't seen in a long time. I actually do want to get your parting thoughts on that right before we go. It was a disaster in 1934, 1935? 37, whenever FDR tried it, he saw a huge institutional backlash. He lost a lot of his own power in the Congress. Would it be a mistake for Democrats to do the same?
Well, I think there are a lot of steps before that, and I think that would be kind of a last resort if anybody is considering that. There's lots of other things they could consider first. But I would say, that we're in a different era right now. I think many Democrats see holding up the nomination of Merrick Garland as changing the number of Supreme Court justices from 9 to 8, at least so long as there was a Democrat in the White House. And so I think that there's so much polarization now, and there's going to be so much concern on the left from what the Supreme Court's about to do, that really it's the kind of thing that's going to be on the table and have a serious discussion if it moves to that level in the next after 2020.
Yeah.
Very interesting stuff, Richard. Thank you so much for your analysis
Thank
today.
you.
We appreciate it.
Take care.
And we'll have more Rising after this.